For our next session, my partner Chantal Bernier will be speaking about securing social license from the start, identifying privacy challenges and strategies. Chantal leads Dentons Canada's privacy and cybersecurity practice after 27 years as a senior official of the Government of Canada, including as interim Privacy Commissioner of Canada. Chantal had the privilege to act as privacy counsel to Waterfront Toronto in the negotiation with Sidewalk Labs for a smart community at Quayside. And thank you so much, Chantal, for joining us today. It's a pleasure as always. Over to you then.
Well, thank you, Kat. I want to salute both your courage and your wisdom in organizing this summit. And I think that both Kelly Gillis and Clint Vince have truly illustrated how this is the way of the future. And it does raise much more than technological issues, going back to Clint's point, and therefore we need to look at it globally. What I hope to share with you this morning then is the lessons that we have learned going through the Waterfront Toronto Sidewalk Labs Quayside project. So if we go to the first slide, I'd like to set the stage. And to set the stage, I would put to you these two main considerations. The first one is that in general, privacy issues do arise from digital solutions that are chosen by municipalities to optimize their services. It is not necessarily the case. For example, Kelly Gillis spoke of digital solutions to establish some food data to ensure food security. That most likely does not entail personal data, but she also spoke of data to assist in prevention of suicide in Inuit communities. That most likely would mean that there would be some processing of personal data. So that is how privacy law is engaged, is that digital solutions do bring us the greatest benefit we've ever had from personal data, but therefore call for commensurate privacy protection. The other point I'd like to make at the outset is that we must not think of smart cities as just one thing, like one whole smart city happens. Actually, smart cities evolve piece by piece. And I put the picture there of Presto because that's an example how in Toronto, a digital solution has been put to the service of optimizing a municipal service. So in the next slide, I take you to the first lesson learned. It is a matter of social license. Anyone, whether a municipality or a private actor choosing to act as a municipality, must understand that it's privacy a matter of social license. If you do not get privacy right, you will not be able to gain the social license from citizenry that you need to roll out the Smart City project. And the example of Sidewalk Labs in Toronto was so illustrative of that, in the sense that even though Sidewalk Labs did everything they could after a while to just bring on the message that yes, 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 we will building strategy to ensure privacy protection, they couldn't quite recover, I believe, the concerns that they had created at the beginning by not putting it really up front. The other thing I'd like to put to your attention is that even though you've had social license at the beginning, you can lose social license if indeed the use of the digital solution doesn't quite stay in line with what you've received social license for. And then I'll give you the example of San Diego smart streetlights. So what happened in San Diego is that in 2017, they chose to install smart streetlights. Those streetlights have cameras that gather data on traffic so that city planners can better identify what street is best for a bike lane, what intersection is most dangerous, where should we put parking spaces, et cetera, et cetera. So it was for city planners to improve traffic and transportation in general. Well, later on, it was discovered that the San Diego Police Service wanted to have access to this data for criminal investigations and more recently to identify demonstrators in Black Lives Matters demonstrations. Big outcry to the point that the mayor was considering dismantling these incredibly expensive smart streetlights. I mean, they did not, but it's an example of how social license that had been gained was withdrawn through a departure from the initial proposition. If we go to the next slide, then we will look at what we saw were the main concerns that kept coming back from citizens as we were doing public consultations. And the first one is the risk of surveillance. Obviously from the state, yes, of course. And I put to you there the example of CCTVs because it's what we know most. And in 2016, Privacy International filed a complaint with the Ontario Information Privacy Commissioner saying that the CCTVs that had been installed in public transportation in Toronto were violating privacy law. And the Ontario Commissioner found that it was not the case. And it's important to see why she found that way. She said, number one, there was a demonstrated need, and that is the test for the public sector to collect personal data. Is there a demonstrated need? There was. The collection of the data, the use of the cameras was limited to that demonstrated need. It was proportionate. And so she found that they were legitimate. But then if we move to surveillance from the private sector, I'll give you an example where it did go awry. And that's starting in 2012, London Olympics, and the City of London decided to put smart bin across the city. These smart bins could push notifications to the cell phones of passers-by in case there was a security threat. So the idea was to help people protect themselves immediately by receiving this notification. 2013, it was discovered that actually the private actor had repurposed those smart bins to actually push ads. Well, that was a departure from the initial purpose, and therefore they were actually removed. That is an example of surveillance from the private sector because, of course, they were picking up device ID to send the ads. The other fear that kept coming up was that of breach. And I will not go very much into the legal details because it is very much a technological issue. Cities are hot targets for cyber attacks because they have so much valuable data and because they don't really have lots of resources to protect it. And so they are prey or at least target of ransomware and fraud. So that has to be taken into account. If we go to the next slide, you will see that not only citizens had concerns, experts did as well. And I'll summarize them to the three main ones. The first one is, how do you get valid consent in the context of autonomous collection? How can a person consent without not even knowing or being made aware of the collection? And of course, again, I'll go back to the CCTVs. But Canadian law has developed a framework around that. So for the public sector, the CCTVs are allowed, as I gave in the example of the CCTVs in a public transport in Toronto, where they correspond to demonstrated necessity. But in the private sector, what is required is that the organization demonstrate that there is enough signage to actually align the expectation of privacy with the surveillance, let's call it that way, and that there is proper signage so that individuals are aware and therefore it's reasonable to imply consent. Then the other issue is the distinction between necessity and convenience in the context of amazingly powerful solutions. So they can do so much. It's easy to fall for, oh, this would be really necessary, when in fact it would be only convenient. And the legal test is necessity, not convenience. But I'll give you the example of smart meters where it was resolved to meet the necessity test because it was resolved that energy conservation was of such public interest that it outweighed the private interest and therefore fell in the necessity category and therefore could be legitimate. Then the consistency of use. So when you have really powerful digital solutions, well, their data that they have could easily be diverted to other uses. And the example I give you here is the San Francisco Bay Area Rapid Transit, where there was allegations, never went to court. There was a settlement out of court that an app that was supposed to tell you where there were security issues in the system was actually tracking people. So there was geolocation to make sure that you could be told where there were safety areas, where issues, but the tracking was an add-on that had not been disclosed to the users. Anyway, settlement and an example of the risks for consistency of use. The next slide, we're going to address a very interesting issue that came out in the Waterfront Toronto Sidewalk Labs issue, and that is data residency as a privacy issue. So if we just take the example of Quayside, no data residency requirements applies there. There is no data residency requirement in FIPA or in MFIPA. There is no data residency requirements in PIPEDA that could impede the transfer of personal data, in that case, most likely, of course, from Canada to the United States. And yet, it was politically unpalatable. There was an issue that municipal data, that extent, that volume, that granularity of data that would have been picked up, were transferred to the United States, was an infringement of data sovereignty. And so opposed. And so what you do about that is that you include in the procurement agreement in a P3 the obligation to keep the data in Canada if the need arises. The next point that I'd like to bring out in terms of the lessons learned is precisely in relation to the P3s. And Kelly Gillis said it very concretely that smart cities very much rest upon P3s because they don't have all the resources and they cannot accumulate all the resources that are related to actually rolling out a smart city. So they are necessary, these public-private partnerships, but they are also raising significant privacy issues. So the first one is that the state and the private sector do not have the same privacy regimes. A public sector institution can collect personal data without consent, provided it demonstrates necessity and proportionality to that necessity. A private sector actor can only collect personal data with consent, either implied or express. So you have to make sure that in every digital solution, you identify properly who is truly the data going to. Is it for the purposes of the city and the state is merely engaging the private actor as its agent? Well, then the privacy regime is the public sector regime. If, on the other hand, the private sector is acting on his own, well, then it is the private sector regime that applies. So that's one distinction that must absolutely be made to assess the privacy rights as how they shake down, so to speak, in the rolling out. The other thing is that we need to take into account the fact that the private sector partner often wants data monetization to make money with this smart city. And yet data monetization is not consistent with the reason that the data is collected in the first place. So let's imagine a private utility that would have a smart digital solution to sell electricity. Well, they cannot then take that data, monetize it for advertisement, for example. There are two ways where that could be done, is if they do get consent, or if they anonymize the data, it is no longer personal data, and then they can offer it for income, of course, as a trend identification data, but not personal data. And if we move to the next slide, this is where I really had a bit of an awakening in the consultations that Waterfront Toronto so wisely set up. Waterfront Toronto, to make sure that they really took into account all of the related issues to the smart city, very much according to what Clint was saying earlier on. It's not just about technology, it's so much more. I mean, we're talking about a community. They set up the Digital Governance Steering Advisory Committee, Strategic Advisory Committee. And that committee was composed of many people who were representing different interests. And some of those interests were people who are facing different abilities than what is, let's say, average. And they brought out some very interesting points. It does not play out the privacy issue in the same fashion for all of us. So the first thing they brought to our attention is the issue of transparency. So for example, I said a moment earlier that with proper signage, you could create a lowering of expectations of privacy in a public-private space, and therefore make it reasonable to imply consent. And they asked us, well, what about people who cannot see? Like, okay, there's signage, but this person cannot see. So you need to think of transparency for the different ways of receiving information. The second one is the challenge of anonymity for people who are different. So the example they gave us, we were talking about sensors. And those sensors, we were told, no, they do not capture any personal data because they only capture how people move and so on. And so one of their representatives said, okay, how about one of those residential buildings, Sidewalk labs that you're thinking of setting up, and you have sensors and they detect movement. And in that residential building of perhaps 100 residents, there is someone who moves differently from anyone else. How is that person anonymous? And we hadn't thought of that, and that has to be integrated. The other thing is, of course, the differential impact of context. Whether you capture personal data in one context or another reveals very different information. And on that, I will not use the Sidewalk Labs example because we did not roll it out, but I'll give you one that is very famous and illustrative, and that is the case of Naomi Campbell. Naomi Campbell was photographed on the street coming out of a rehab clinic, and she sued. And the photographers and the newspaper said, no, it's just, we're a public figure, we had the right to portray her, photograph her walking on the street. And her lawyers made the point that, no, you did not reveal her walking down the street. You revealed the fact that she was attending a rehab clinic. That is not the same thing. And indeed, in Canada, since R.V. Spencer, Supreme Court of Canada 2014, the Supreme Court made it very clear that personal data must not only be judged as to what it is, but also as to what it reveals. And therefore, context is very important. And the final point that diversity brings along is the fact of algorithmic bias. So algorithmic bias comes from the fact that algorithms are actually developed by human beings, and human beings are biased. And so it's very important to build in protections from that. To give an example, the Government of Canada has adopted guidelines on algorithmic transparency, as well as guidelines on producing algorithm impact assessments, so that should there be a bias, you can at the very least not only avoid introducing it, but if you do inadvertently introduce it, you can correct it. In the private sector, of course, we have clients who use sociologists, psychologists. One of my clients used an anthropologist to ensure that the algorithms are not biased, but that is an issue that definitely must be taken into account. And so in the last slide coming up, I want to conclude, I would say on a positive note, in the sense that throughout the Quayside project, I was constantly reading, of course, about cities that have already used extensively digital solutions and did it right. And Barcelona always came up as the model, and therefore giving us the illustration that yes, you can harvest the power of digital data for the good of everyone while protecting the privacy of everyone. So this is really very short explanation of the main lessons we have learned from that project, but I'll be happy to answer questions, Kat.
Thank you. And thank you so much, Chantal. That is informative and fascinatingly interesting as always. We do have one question for you in the Q&A chat. And it is from Fabiano. And Fabiano says, great point, Chantal. It is a normal belief that the social license is one-time process, and it's not. It's a continuous vigilance of your strategy, in brackets considering department integration, close bracket, and communication plan towards communities. Do you see information technology helping municipalities avoid the lack of integration that generated the case you've mentioned in San Diego?
Yes, absolutely. And indeed, if you look at Estonia, which is more than a smart city, it's a smart country, right? They use technology not only to enable the data collection and use, but also to enable its protection. So for example, they have what they call X-Road. And so the departments are impeded technologically to go and pick up data that belongs to another department and therefore come up with triangulations and generating data about individuals that would exceed what the state can actually harvest and use. So yes, absolutely there. And in fact, Barcelona is also an example of that. One technology that is privacy protective in the Barcelona environment is blockchain. So yes, they have created an access so individuals can go into their account and find out everything that the city has about them. But that is protected by blockchain. So there is both technical enabling and technical protection. I would also add another thing, Kat, is that there are also governance measures that can be taken. And I will refer to Metro Links. So Metro Links did come under the suspicion that the data that would be picked up by the Presto cards could be accessed by law enforcement authorities for other purposes than the purposes for which the Presto card was given. And so what Metrolinx did was, first of all, adopt internal guidelines that are made public, but that govern them as to whether they accept or not a law enforcement request for personal information, because there are circumstances where it would be legitimate. So those are well defined. And secondly, Metrolinx has transparency reports that they produce every year and that tell us these are how many law enforcement requests we've received. These are how many we've accepted. This is how many they've been rejected. And these are the main grounds for those law enforcement requests. For example, criminal investigation or finding a missing person. So governance is also a area where you can bring privacy protection.